So somebody said Mark Nichols needs no introduction, but I beg to differ. We have a lot of new people that may or may not know. He is one of us, a Northwestern Rotarian, but he's also I call a huge figure in our community. So just to share a little, Mark Nichols was born and raised in Seattle, Washington. He obtained his Bachelor of Arts from the University of Washington and his law degree from Seattle University School of Law. He has served as Clallam County's prosecuting attorney and ex-officio coroner since 2014. Prior to being elected, Mark served as Clallam County hearing examiner, spent over a decade working in prosecution, and served as a federally commissioned U.S. park ranger in Arizona, New Mexico, Texas, and in Washington in the Quinault and Lake Crescent districts of Olympic National Park. Mark is a certified instructor with the Washington State Criminal Justice Training Commission and belongs to numerous professional associations, including the Washington Association of Prosecuting Attorneys, where he currently serves on the executive board, the Washington Association of Coroners and Medical Examiners, and Fight Crime, Invest in Kids. In addition, he is a gubernatorial appointee to the Washington State Forensic Investigations Council, which he has chaired by a vote of his peers for the last several years. In his spare time, Mark enjoys hiking in the Olympics, fishing for salmon and steelhead, landscaping, and spending time with family. Mark likes to start each morning at work with a quote. Today's quote is from one of my favorite people, Walter Cronkite, who said, "Ethics must be reintroduced to public service to restore the people's faith in government. Without such faith, democracy cannot flourish. Your ambitious agenda is filling a desperate need." Come on up, Mark. I'm so happy to have him and Tom, both in one day.
Wow. Good morning, everyone. I'm just trying to figure out the best place to stand. Is there, for the folks on Zoom, let's see, trying to figure out what their perspective is.
Oh, they can just see the slideshow.
Okay. And for folks on Zoom, can you hear me all right? I'll just speak up a bit. And so it's a real pleasure to be here and see so many new members to the Northwestern Rotary Club. I actually am one. And the reason I say that is I haven't been here in person in at least 2 years, I would say. Starting with the advent of the pandemic and the change in club behavior for obvious reasons. So too did my behavior change, and my work schedule's become a bit busy. So you might have seen me on Zoom, but it's great to be here in person. And I'm gonna try to do my best to get back here more in person. I get a lot more out of these meetings that way. I put together a presentation actually for the Kiwanians, and so Mark has seen this before. And it went over, I thought, pretty well with the group. I actually presented this same presentation out at Forks for their chamber not too long ago, and they really enjoyed it. And so I thought, why not share the wealth with my own Rotary Club? The topic of the presentation is forecast, a term we're all familiar with. Forecast means to predict or estimate a future event, most commonly coming weather or a financial trend. And go ahead and if you could advance the slide. And so when we think of a forecast, we think of the weather usually, and most of us, we would like to hear a forecast that calls for a lot of blue skies, sun, maybe a few light drifting clouds. Other times, the forecast calls for a weather front to come in, and other times still, the forecast is for stormy skies or an intense storm to hit us. But the term forecast is not used just in relation to the weather or anticipating financial trends. It can be used in relation to other subject matter, including the behavior of our courts as they go about addressing the treatment of a particular subject matter. And so for today, I thought we would talk about unauthorized sitting, flying, or camping in public places, because this is a This is a topic that has received quite a bit of treatment, certainly within the court system, but also within a court of public opinion. One arguably drives the other. And so I am a true believer in trying to help educate folks about what is happening within the courts, especially if it impacts you in your day-to-day lives. And so for anybody who's driven through, say, San Francisco, Seattle, or Portland over the last 10 years, you might have noticed some changes, especially along the 5. And those changes include the development of 10 cities, issues surrounding homelessness as a broad topic, and it's a vibrant source of controversial discussion. And so this presentation is designed to provide a little bit of explanation surrounding the why behind the what in relation to what we have seen develop by way of activity, not just in the major city centers along the West Coast, but also in smaller towns and jurisdictions like Clallam County, Port Angeles, Glen, and Forks. And so without further ado, I'm going to talk a little bit about a case captioned Martin versus City of Boise. This is an opinion out of 2019 that people may have heard about, but they may not really know about. And so I think the best presentations are those that don't just make reference to court cases, they actually talk about the facts and tell the story of what happened, because that helps frame why the court decided the case the way that it did. The print's a little small, and so I'm going to read this so that folks can follow along and oh, fantastic, and enjoy their meal at the same time. By way of highlight of the facts, the city of Boise, Idaho had a significant and increasing homeless population, and it housed 3 homeless shelters. One was operated by an interfaith sanctuary housing services and was open to men, women, and children, and notably did not impose any religious requirements on residents. The other 2 were operated by Boise Rescue Mission, a Christian nonprofit organization, and imposed various conditions on residents, such as gender segregation. So one of the facilities was open to women and children, for example. The other was open to men. There were check-in times. If you didn't show up by 5:30 p.m. Or between 5:30 and 8, you would be turned away. There was a limitation on the duration of stay, which we'll come back to shortly. There was one individual who provided testimony that he was required to attend chapel as a precondition to being able to eat dinner within the shelter. And there was a requirement to join a discipleship program in order to remain longer than a set period of days in the 2 facilities. There were 2 primary programs provided for the homeless: the Emergency Services Program and the New Life Discipleship Program. Except in the winter months, male guests in the Emergency Services Program could stay up to 17 consecutive nights. Women and children in the other program could stay for up to 30 nights. After those time limits were reached, homeless individuals who did not join the discipleship program were kicked out of the shelter and told that they could not come back for at least 30 days. Participants in the Emergency Services Program were required to return to the shelter every night during the applicable 17 or 30-day period. If they failed to check into the BRM shelter each night, the resident was prohibited from staying overnight at that shelter for 30 days. BRM's rules on the length of a person's stay in the Emergency Services Program were suspended during the winter months. The discipleship program was described as an intensive, price-based residential recovery program, of which religious study was the very essence. The court record does not indicate any limit to how long a member of the discipleship program could stay at a VRM shelter. There were 2 statutes at issue in the case. Boise's disorderly conduct ordinance on its face criminalized occupying, lodging, or sleeping in any building, structure, or place, whether public or private, without permission. Boise's camping ordinance criminalized using any of the streets, sidewalks, parks, or public places as a camping place at any time. And it's important to note that the ordinance interpreted the phrase camping extremely broadly. The plaintiffs sued, alleging that actually, I think there should be one slide that we might have jumped past. Okay. There we go. Just to frame this properly. So the plaintiffs were all homeless individuals who were cited for violating the camping ordinance, the disorderly conduct ordinance, or both. The plaintiffs sued, alleging that their previous citations violated the cruel and unusual punishments clause of the 8th Amendment. It's important to note that after the lawsuit was commenced, the Boise Police Department promulgated a special order that prohibited enforcement of either the camping or disorderly conduct ordinances on any night where no shelter had an overnight space available. And we'll come back to why that's so important later. The shelters were to notify Boise Police Department by 11 p.m. if they were full. This came to be known as the shelter protocol in Boise at the time. So the central question that came before the court was, does the cruel and unusual punishments clause of the 8th Amendment preclude enforcement of a statute prohibiting sleeping outside against homeless individuals with no access to alternative shelter? The court noted in its opinion that the cruel and unusual punishments clause circumscribes the criminal process in 3 ways. First, it limits the type of punishment the government may impose. Second, it prescribes punishment grossly disproportionate to the severity of the crime. And third, what became at issue in this court opinion, was that it places substantive limits on what the government can criminalize. The court started its analysis by quoting a case out of California. You can go ahead, if you could advance to the next slide, or excuse me. Sorry about that, you can go back one. Okay. The court started its analysis by quoting a case from 1962 captioned Robinson versus California by saying even 1 day in prison would be a cruel and unusual punishment for the crime of having a common cold. And in that case, what was at issue was the fact that the condition of having a cold had actually been criminalized as a rule. Something that the courts found was reprehensible in law and unsupportable. And so that's what was struck down in 1962. The court in this case focused on the principle that the 8th Amendment prohibits the state from punishing an involuntary act or condition if it is the unavoidable consequence of one's status or being, and noted that whether sitting, lying, and sleeping are defined as acts or conditions, they are universal and unavoidable consequences of being human. These are things that we have to do regardless of who we are, whether we want to do them. And the court ultimately held that so long as there is a greater number of homeless individuals in a jurisdiction than the number of available beds and shelters, the jurisdiction cannot prosecute homeless individuals for involuntarily sitting, lying, and sleeping in public. Stated somewhat differently, so long as there is no option of sleeping indoors, the government cannot criminalize indigent homeless people for sleeping outdoors on public property on the false premise that they had a choice in the matter. The Ninth Circuit Court of Appeals ultimately ruled that it is unconstitutional for the city of Boise to enforce ordinances prohibiting camping in public places against homeless individuals at times when no shelter space is available. Because Washington State is part of the Ninth Circuit, this published opinion became binding law for us. But it's important to note that camping ordinances are not inherently unconstitutional, but a municipality can be in violation of the 8th Amendment if the person cited had no meaningful alternative to sleeping outside. That's really at the heart of the court's opinion. as courts often do, they drop footnotes within their opinions, and the devil's in the detail. Oftentimes, I read the footnotes first before reading the body of the opinion, because that's what good stuff is. And so in footnote 8, Martin opinion, the court identified that its holding is really quite narrow, and it spoke to what the holding doesn't cover or address. For example, the court stated its holding does not cover individuals who do have access to adequate temporary shelter, but who choose not to use it. Further, that even when shelter is unavailable, an ordinance may still prohibit sitting, lying, or sleeping outside at certain times or in certain locations. The court further identified that an ordinance may prohibit obstruction of rights of way or the erection of certain types of structures.
Yeah.
And ultimately opined that whether such ordinances are consistent with the 8th Amendment will depend on whether it punishes a person for lacking the means to live out the universal and unavoidable consequences of being human. And so Boise strongly disagreed with the Ninth Circuit Court of Appeals decision in this case and sought review before the Supreme Court of the United States. To the surprise of many, the court refused, allowing the lower court's ruling to stand. The Supreme Court did not explain its decision. It's quite possible that the justices considered the issue moot, since Boise had already repealed part of the ordinance that was at issue, and the police department had implemented the shelter protocol that we referenced earlier in the presentation. And so that's been the law of the land for years. And it's largely based on Martin v. Boise that we've seen municipalities change their behavior in relation to how they've attempted to regulate homelessness, recognizing that there's tremendous liability that attaches if they get it wrong. They can subject themselves not only to getting criminal convictions overturned, but to civil liabilities that require them to pay money. 5 years after the Boise decision, the High Court has been once again asked to weigh in on the constitutionality of anti-camping laws. And so one of the things that I like to point out, going back to the topic of presentation forecast, predicting events to come, is that there's another opportunity for the higher courts to take a closer look at the Boise court's decision from 2019. On August 22nd of this year, the city of Grants Pass, Oregon, petitioned the Supreme Court of the United States to hear a case captioned Johnson versus City of Grants Pass, a case that, like the city of Boise, involved the circuit. Grants Pass wrote the following in its petition for a writ of certiorari. The question presented is, does the enforcement of generally applicable laws regulating camping on public property constitute cruel and unusual punishment prohibited by the 8th Amendment? Sound familiar? Should, because that was essentially the same question that was before the Martin Court in the Boise decision. If and how the Supreme Court decides to answer this question, it could obviously have massive implications for municipalities all throughout the Ninth Circuit Court of Appeals. The Boise decision put a straitjacket on West Coast governments, argued the dissenting judges in Grants Pass case. Homelessness has exploded in the 14 years since that court case. Los Angeles alone, 75,000 people remain unhoused on any given night. Crawling encampments have contributed to public health and safety issues in major cities. And again, I think we see most evidence of that regionally in and around Seattle and Portland. California is a little bit out of our wheelhouse, but still falls within certain proportions. So I'm going to pause there before I transition and provide a little bit of an update about some goings on in our coroner division and ask if there are any questions about this. Yes.
So in the Boise decision, it said that you provide other areas that have an option for camping or other directing homelessness crisis to an area that's acceptable, like outside of town, or that it would be acceptable. Do you see that be a solution for communities, or how does that play?
The Martin Court really focused on the need for there to be available overnight shelter. And so I think most have interpreted that to mean that we need to have a sufficient number of shelter bed spaces available to house the homeless community. In circumstances where there, only in circumstances where there is no available shelter bed space, can an ordinance not be enforced. In other words, if a person doesn't have a choice but to sleep outside, you can't criminalize that conduct or behavior. If there's a shelter space available, say, for example, at Serenity House, and the person chooses not to go voluntarily, then you stray into the realm of potentially being able to criminalize the conduct, although there's a number of logistical issues that you probably want to address before doing that. And so how this translates, I think, to the streets of Clallam County with the 3 cities within it is that if you take, for example, the park behind Swain's, an area that I think most of us have probably seen or are familiar with. There are people who camp there. And if a law enforcement officer were to approach one of them and engage them or attempt to engage them in a conversation regarding the legality and lawfulness of their camping, they're going to need to at the same time be figuring out whether there's bed space available anywhere. Could be in Serenity House, could be in a local church, for example. If there's bed space available, then the challenge becomes trying to get them there. We have other programs that have been created that can help in relation to that effort, rediscovery programs and such. But it's more logistically complicated to deal with the population of folks who are homeless, given the whole important. And so simply moving people around doesn't necessarily solve the underlying problem. Let's see, John, and then Norm, and then, yeah, my order.
Mark, just a question. If there are protests going on, public agencies can designate where the protest, they have to allow the protest to take place or disagreement, but they assign areas where people can exercise their freedom of speech.
Yes.
If you would apply the same concept, people can camp, but only camp in areas where facilities are provided for going to the bathroom. Otherwise, if they go out of those places, then that is a health and safety issue. So would that approach be acceptable under the law?
That's a great question, and it's one that I think is going to invariably be answered probably through the court system, because one of the things that we've seen develop is that as time has passed, and as there has been an increase in homeless encampment activity throughout many jurisdictions around the West Coast area, different communities' tolerance has developed or waned in different ways. We've seen some jurisdictions, especially of late, seemingly reach a bit of a breaking point. And what they're starting to do is change their approach to homeless encampments. Part of changing it is to try to do just what you're describing, designating areas where they're trying to incentivize folks who are homeless to establish tent cities. But the lawfulness of those efforts really is borne out through footnote 8 of the Martin decision is going to be fact dependent and probably need to be tested through the court process. And so there is no case that says, yes, you can do that. That is lawful. The language is more nebulous, and it's going to need to be the case that it's as applied analysis to determine whether a particular municipality's ordinance or policy of trying to incentivize folks to locate in one area passes legal muster. And that's I think that's been part of the challenge practically for governments throughout the Ninth Circuit, is that not many of them are positioned to be able to bear the cost of litigating the constitutionality of their own ordinances. These things have a way of taking on a life of their own, and so the price tag on the litigation itself can be overwhelming for a smaller mid-sized jurisdiction. And so out of an abundance of caution and out of a sense of fiscal responsibility to their constituents, what they don't want to do is run the risk of adopting an ordinance, having it challenged and being brought into court potentially for years on end. And then if they lose, to potentially be subjected to some form of action for damages based on a theory that they violated someone's civil rights. And so from a legal perspective, those are the conversations that we have in prosecutors' offices, I think in city attorneys' offices throughout the Ninth Circuit is, you know, is there such thing as a safe ordinance anymore in light of the Martin Court's decision? Where do we think the lines have been drawn? How far can government go before it strays into the gray and exposes its flank to a legal attack, the outcome of which is unpredictable at best? Nora.
So, I mean, there's a wide variety of shelters in, around the community, I guess, and you talked about that. So to what degree can a community, legally, provide limitations on whether a person can actually stay in a shelter, as long as it doesn't violate other civil rights, such as, race, creed, color, sexual orientation, etc. You know, those things that are already protected. I mean, if a person was violent, completely whacked out on drugs, you know, are those limitations that can be imposed and still not be in violation of the court case?
I would like to say yes, because if I'm a shelter operator, I think I have to be sensitive to the liabilities of running the shelter. And that would tilt in favor of having some uniformly applied, applicable policies that would be designed to safeguard the health and safety of the shelter population. And so no pets into a shelter who has a dog that may be vicious, that could bite someone, that's going to create a problem. It's a bit of an unanswered question on some level. What restrictions would be allowable? Because again, in the Martin Court decision, they happen to focus on the imposition of religious requirements. But that doesn't mean, or that's not to say that a court may not choose to focus on other restrictions that were put in place and take issue with them as well. And so again, that's one of the sets of questions that was raised by the Martin Court's decision that was unfortunately left unanswered, and there wasn't more guidance provided through the footnotes for the benefit of local jurisdictions as they go about regulating this area of law. And so I think there probably are shelters in Clallam County that do have reasonable, I would say, restrictions that are designed to safeguard the well-being of the shelter population. Even if I think they're reasonable, that doesn't mean that somebody else does. And therein lies the challenge, because all it takes is a creative attorney, nothing against my own, to craft the argument that this shelter was actually only open to folks who were willing to comply with its restrictions, some of which crossed the line and should be struck down. And I could see them citing very easily to the Martin Court in support of that legal theory and attack. And so I think, to be clear, it makes sense that folks who maybe have dogs, unfortunately, might need to be excluded. Because you never know if the dog's vicious or not, really. But by virtue of that exclusion, you may set yourself up for a problem under Martin Nichols. There could be other restrictions as well with regard to check-in hours and such, which were highlighted in this case that proved to be problematic as well. And so those are some of the unanswered questions. Your question is great, and it raises.
Mark, I'm gonna carry on with that same thought. Serenity House is almost empty. And they have a lot of space. They do have a van. Most people. So do we in the city or the county ever force county and to follow on with that? Cities like Belgium don't seem to have this problem. At least it's not on.
So for those who could not hear, I'm gonna paraphrase. Grant asked kind of a twofold question. Number one, do I see enforcement of anti-camping ordinances in and around Clallam County? Was potentially one question. And the second was, how come in some jurisdictions such as Bellevue, it seems that they don't have the same degree or at least optical display of homeless encampments that exist in other jurisdictions? How do they do that? To answer the first question, what I will say is that law enforcement in Clallam County, I think, is very careful to address the conduct surrounding the camping industry. And so the effort is to try to get people who are homeless and unhoused into a shelter environment. And you're right, places like Serenity House play a great role in that. Getting people from where they are to Serenity House can be a real challenge. The Serenity House shuttle is great, but you have to get to the pickup point. And if you're traveling with a small house, that's easier said than done. There are other bridge resource programs that are designed to help get people there. Mostly what I see are law enforcement agencies addressing the criminal conduct surrounding the camping. So if there's criminal trespass issue, that is how they will address that. For example, if somebody, thank you on the 5-minute limit, if somebody is, fixing a tarp to the side of a commercial building using screws and nails, we call that malicious mischief in the law because they're damaging another's property. If somebody is disorderly in conduct, there's a statute that actually criminalizes that. So what we wind up receiving by and large are referrals from the men and women of law enforcement for those crimes that address their conduct surrounding camping behavior more often than getting in unlawful camping referrals. Usually the effort is try to get them into the shelter. There are ongoing problems that sound like crime, refer that as a crime, and then we charge those for it. Places like Bellevue have taken a more hardline approach. And I would note that Bellevue is not Clallam County, it's not Grace Harbor County, it's not Jefferson County. It's a large metropolitan jurisdiction with a behemoth city attorney's office, quite a bit of financial resource to throw behind it. So they have a more stringent code that they've adopted addressing the subject matter. I'm not aware of any challenges that have been filed in relation to it yet. That's not to say there won't be. And so Bellevue is a good example of a jurisdiction that has decided to experiment by pushing into the gray in an effort to control this behavior, either by relocating or eliminating within the jurisdictional bounds of the city. I'm going to move on real quick, just so I can give you a brief update on the coroner function. I'll stick around after the program for anybody who has further questions. Moving on from the topic of buying, sitting, sleeping in public, which really sounds more of a prosecutor and municipal government related issue. For those who don't know, the county prosecutor here also serves as the county coroner, and that's by virtue of our county charter. We have been undertaking an effort over the last year or so to build out an independent coroner division within the broader umbrella of the county prosecutor's office out of respect for the independence of the functions. Coroner on the one hand, prosecutor on the other. It's also the case that our population has gotten to the point where the mortality activity that's occurring has really taken on a life of its own by the time and warranted a standalone division of folks to help shepherd this important function. And so while I serve as the prosecutor and the ex-officio coroner, I have two full-time equivalent employees who are by and large pulling the laboring oar in relation to the coroner function on a daily basis now. Nathan Millett, who's my medical legal death investigative supervisor, and Natalia Stadler, who's a medical legal death investigator. She's also a nurse. They're both fantastically experienced folks in relation to all things death investigation related. And so they have been hard at work. In September of this year, the three of us went through a week-long certification program with a series of book study, written tests, passed that. And so we are officially certified as medical legal death investigators in the state of Washington. To give you a snapshot update on what's happening in our community, by way of the number of coroner cases, you can see those depicted across the top row. Back in 2018, we had 208 in that calendar year. It jumped up to 240 in 2019, 291 in 2020. You can see the progression. And through the end of November of 2023, we had 314. If you do the math and extrapolate forward, we anticipate we'll end the year with about 343 coroner cases. If we look just at this year, maybe as a focus, with regard to the number of autopsies that we've had performed, by the end of November, we had 72. By the end of the year, we're anticipating a number probably closer to 78. On the suicide front, we have 19, actually calendar year to date. We'll probably, unfortunately, tragically pick up one more by the end of the calendar year. We've had 2 homicides, 44 accidental deaths. We'll likely pick up another 4 or so more by the end of the year and come in at about 48. Drug overdose remains probably the most startling and tragic data point, because calendar year to date, we know we have 25 confirmed fatal overdoses. We're waiting on lab test results on almost an equal number that I'm almost certain are going to come back positive for probably a combination of fentanyl and methamphetamine both. It's very likely that Clallam County is going to experience 50 fatal overdoses or more by the end of this calendar year. The previous record was from 2021 when we had 35 fatal drug overdoses. And so I never stop talking about this because this is a trend heading in the wrong direction. There are a lot of people dying on the streets of Clallam County from drugs. And I think that speaks to a major problem for everyone. Our lawmakers, our policy wonks. I think people need to take a critical look at what, if anything, can be done to turn the tide in relation to that particular trend. And so I started out by talking about forecasts, and we saw a slide of blue skies, light clouds, maybe a little bit of sun. A separate slide depicted the incoming weather front, and then there was a stormy scene. Notwithstanding all the problems that we hear about in the news, there's a lot of good things going on, and we live in a beautiful place. And so from my perspective, it's paradise. Just like that. One more, and one more beyond. I always include a fishing picture. And I know there are some fisher folk within the audience. This is taken on the, let's see, right by line deckers in front of what we call the motel hole. So that was about a 22-pound king caught on a spinner and released back into the river system. I really appreciate folks following along. I hope that you got something out of the presentation. The greatest takeaway is that if you perceive that you've seen a change in behavior regarding homeless encampments and issues surrounding them over the last decade or so, you're really not crazy. And a lot of what explains it primarily starting from 2019 on, is the Martin case. And so we'll see whether the Supreme Court accepts review on the Johnson versus City of Grants Pass case, and if it does, we'll see how they decide that. There's obviously been quite a bit of attention focused on SCOTUS, the change in the constitution of the court, philosophically and otherwise. The political pundits and legal prognosticators are all out talking about what could and might happen should the High Court accept review. I would expect that there might be a decision that would provide a little bit of balance, more so than exists at present, and balance that would provide a little more guidance to governments as they go about trying to regulate this conduct and set of behaviors to the betterment of all. Thanks.